Have a call.
Russ Narcan. Kim O'Connell appears to be absent. Keith Karpinski,
Here.
Fran Duncanson. Here. And Jake Luke.
Here.
Did
4 out of 5 today. I'm good.
Kim mention anything?
No. He maybe is not aware or forgot. I'm not sure. He's
You want me to
usually,
call him just to make sure?
he's usually here, so.
Yeah, he is.
It's not like he's a new chair.
Not like him not to let us know if he's not gonna attend. But we have a forum, so we're going on without him.
Good.
A motion to adopt the agenda.
I make a motion to adopt the agenda as presented.
Second that.
Any discussion on the agenda? If not, all's in favor?
Aye.
Carries. I'm appointing Keith Karpinski as the chair of this committee and Fran Duncanson as the vice chair. So I will turn the meeting over to Keith.
Okay. Congratulations. Yes.
Isn't it?
Sure.
So, let's see here. Adoption of the minutes of the April 9th meeting.
I'll make a motion to adopt them.
I'll second that.
Okay, motion's been made and seconded to adopt the minutes of the April 9th executive meeting. Is there any further discussion? All in favor signify by saying aye.
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 Any opposed? Motion passes. Public comment. Anybody? Note that there's none. Supervisors not seated as committee, wait a minute, yep. Supervisors not seated as committee members. Got something, Pam?
I guess not specifically, other than I was in favor of a lot of the changes that were made or that were proposed originally. And I just wanted to hear kind of how this committee vetted them out since there was some more discussion at the last board meeting or more comments at the last board meeting. So I just wanted to be at the table to kind of see how things were. So whether that's official or not, that's my statement.
We did get some comments from another supervisor. He wants his comments addressed and probably while we're discussing the rules of order.
Is that from Brad or?
No, from Adam Jarko.
Okay,
So
okay,
just so that we include them when we have the discussion.
sure. All right, we'll move on to discussion regarding amendments to the Rules of Order, Chapter 2, Article 2. The Joe was something on that, right?
I do. So
There's some, Joe, besides what Adam brought forward, did we have some others that we needed to finalize?
I have just some clerical changes and some technical changes that I wanted to suggest as well. One is in section 254 under amendment procedure. That lays out that rules are to be adopted at the organizational meeting by a majority vote. I think that obviously, well, I don't think, we obviously did not adopt the rules at the organizational meeting. We sent it back to committee for further review and to allow the new board members time to take a look at it and submit any comments if they wanted to for the executive committee to consider. I propose that we add language to that first sentence that says these rules of order shall be determined by a majority vote at the organizational meeting of a newly elected county board, or as soon as practicable, if it is referred back to executive committee for review by the organizational or by the county board at the organizational.
Where are you?
Adding to the next sentence, once adopted,
Yeah.
amendments to these rules of order shall be, et cetera, et cetera, et cetera.
And where did you change that? Or
Sorry, that's section 2-54
It's page 3 of 19.
Okay.
sub B.
page 3?
3 of 19.
Okay, I went by it.
That's a proposed, really more of a clerical change and just practical change, because again, we're not always necessarily going to be able to sit down and hammer out the rules of order at an organizational meeting with new members, and especially if we're proposing somewhat substantial changes, it's going to at least one additional committee meeting for people to have an opportunity to voice their opinion. I had that.
Is there more to that or are we?
I also found a typo on page 8. I would just suggest maybe moving to allow clerical errors to be modified in the document. That way they can be changed. I don't think outside of responding to comments from
Now, where is that one?
Page
the
8 of 19.
Page 8?
the typo. Typo is on page 8 of 19,
And then A, B, C, D,
sub G.
G.
Just simply says any supervisor, third sentence in, any supervisor attending a board or committee meeting remotely shall keep the camera on for the entirety of the meeting if by attending by video. So it's a double, it's just a clerical error again.
Fixed it.
Just the first by is getting struck.
Correct.
Okay.
Additionally, page 10 of 19, the clerical error, the top sub K, section 2-57, resolution adopted by the county will be signed by the county board chair and attested by the county clerk. So adding the words by the.
Oh, you mean after that?
And then at the very end, page 19 of 19, I suggest changing very last section there, sub D. Says, in addition to the enforcement procedures established in this section and without limiting any of those provisions, the board chairperson may refer any violation of these rules to the, I would strike executive and say ethics committee. Currently, the executive is the ethics committee, but technically they're acting as the ethics committee. So a referral on ethics goes to the ethics committee, and theoretically that could change to a different committee, or a different committee could be created. So I think just saying ethics instead of executive is appropriate there. And such referral shall be considered I would add the word verified before complaint, only because that's the language used in our ordinance is verified complaint. So I would add that, and then at the end of the sentence, add under section 2-55 sub I sub 3, which is the section for verified complaints.
What were your subsections, Joe?
2-55 sub I, lowercase I, sub 3. And actually, sorry, one more. Under subsection C on that same page, at the very end, it just says, shall comply with Wisconsin state statutes. I would just change that to Wisconsin State Statute, Chapter 17, since that is the specific chapter that addresses removal of a county board member. Those are my clerical changes. I do not have myself any substantive changes recommended. I do have some recommendations based upon comments from Supervisor Jarko. So I don't know if you want to hear all of my recommended changes right now, or if you want to take those as they come while we go through the rest of it.
We should probably take them as we go through it.
Okay, so those are my personal clerical corrections. There were no substantive real changes that I would recommend just on my own without the comments from supervisors.
Do we need a motion or anything for those changes? I don't believe so. Wouldn't the clerk just make the changes and for the next,
So we have a resolution drafted to approve the rules. I think it would be cleaner to make a motion to adopt the changes suggested by Corporation Counsel on the record, and have that voted through. And any additional change, I think we should, even though we haven't, it's not necessarily formalized yet, because we have a resolution drafted, it's arguably a modification to the resolution.
so we should have at this point then a motion to adopt clerical and wording changes suggested by corporate counsel.
I'll make that motion. Because we're gonna be addressing them and they'll be accurate at that point.
Right, so you'll be amending the language, and then when it goes to the county board, they'll have another opportunity to amend again.
Okay, I'll
Okay,
second that.
we've got a motion and a second.
I make a motion.
Is there any further discussion? Madam Clerk has the motion. Okay. Well, no further discussion. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion passes. All right. So now we're moving on to go through it line by line, basically, or section by section.
Mark?
We certainly can. The clerk and myself worked on this with the previous executive committee. Many of you were on the previous executive committee.
Right.
Many of you, or all of you, were on the previous board. So I think there has been anything substantive since the last discussion that was had at the board that changed. We can go item by item through them if you would like. Otherwise, we could just address the comments that came in on what was previously proposed.
I don't know that we need to go through item by item all day.
The only two things that I have is, Russ, was a question that you had brought up regarding like the reimbursements, if you wanted to talk about that further and what's covered under the salary when you had that question.
Yeah, I was just gonna ask, I mean, if I'm called and asked to come up to sign something, do I put in for mileage or do I not?
Yes.
Do? All right, well, I wasn't sure, so I thought we'd get it in front of the committee and.
I think that's been the general.
Well,
Consensus.
It has been a practice in previous, but it's never been addressed as to what is covered under the salary and what isn't. And that was part of the reason I brought up that the last time when we had this discussion, is making sure that's clear in the rules. So staff isn't trying to determine what should be paid out and what isn't. It should be clearly outlined as to what the rules are, what the salary covers, and what is in addition. And it's totally fine whichever way you want to go, but to kind of codify that, just so staff isn't making that determination for board supervisors.
Usually mileage is a separate item from
Yeah.
a salary or a wage or whatever. So I would say it's not included.
It was, Chris, for an example, did not take it. He indicated that he did not take it as it was possible to, because he lived in Balsam Lake and he was here all the time. I don't know that I ever, I might have done it once or something. But I generally do it when I was here, you know.
I mean,
Or electronic signature.
so you're not getting anything additional time, but I think mileage is fair
Well,
for
if it's,
my own
if you,
2 cents.
an electronic signature is pretty well utilized nowadays, I think.
Yeah,
Does it come up often where you have to make a trip up here just for one item or one?
I did it maybe once or twice.
Yeah, it's, I mean,
yeah, I don't think it,
put in for the mileage, it's not a big deal.
but is it in the rules? Under page 2 of 19, compensation of supervisors and chairpersons. Is it in there that,
I think not specifically, no. When you have to come for a signature.
We did have the discussion last time, and it is in there that attendance at the voluntary events shall not receive the per diem nor mileage, but it doesn't have anything outlined specifically for the chairperson. I think we could fit that either, and maybe Corp Council has a recommendation, putting it either on the compensation of supervisors or putting it in the duties of chairperson, just saying, you know, when the chairperson's presence is requested at the county, they may put in for mileage. Maybe that falls under duties and responsibilities.
it would be, you know, but a meeting, if they ask the chair to attend the meeting, you're not attending it as a member. You would only be attending it as a spectator. And would you then get, I know you wouldn't get a per diem because you're not actually participating in the meeting, but would you get mileage?
Never thought about it. Good point, though.
But should, if
So we added,
mileage is gonna be paid, it should say so.
we added the language that says chairpersons may not receive additional compensation for attending standing committee meetings, of which they are not a member. That specific sentence does not address reimbursement. You could change that to say chairpersons may not receive additional compensation or reimbursement for attending standing committee meetings of which they are not a member. That's not going to address the issue of coming into the government center for a signature if necessary. I mean, I know back when Dean Johansson was the chair, I once had to drive to his residence because he couldn't make it here to get him to sign something. That there are emergency situations from time to time that require actions. And I think we all understand that for the chair to take, to do certain things. Whether you want the mileage reimbursed or not, if you make a decision, or ultimately the county board makes a decision, we can certainly add the language in pretty easily to say yes or no. Because there are going to be situations where the chair is going to have to come in, or someone's going to have to go to the chair or something in an emergency situation.
I mean, Russ has a little ways to come in an emergency situation. And if it's an emergency, it disrupts, whatever else that person has going on, and they're not getting anything additional for their time. I personally think mileage, to give them mileage would be fair.
I think it's a little different situation if the chair wants to attend a committee meeting out of curiosity and see what's going on and get informed is one thing. But if someone on the committee or someone requests the chair to be there, I think that mileage would be appropriate.
Well, and it kind of addresses that if he's there voluntarily, it's not reimbursed.
Right.
So we could just add it to that subsection B where Joe just was and just say chairpersons may receive mileage reimbursement when their presence is requested
Or required,
or required.
on requested, I guess. 'Cause I guess if they would just request you to come to the meeting, you wouldn't have to.
So yeah, you could change that sentence to chairpersons may not receive additional compensation or reimbursement for attending standing committee meetings of which they are not a member unless their presence is required to establish a quorum or requested by the chair of that committee.
But that doesn't address when they come to the county to sign stuff then.
Still does not address coming to the county.
So what if we separate that out and just say chairpersons may receive mileage reimbursement when their presence is requested or required? That could be by the committee chair then. That could be the administrator. It could be the clerk's office if we need signatures.
Suppose. It's required to establish a quorum.
So the standing,
That particular sentence is contemplating standing committees. That's the presupposed situation, is the standing committees at the beginning of that sentence. So you'd have to have a different, it would have to be a separate. You wouldn't be able to just tack it onto that sentence. You'd have to add
Another whole sentence.
which again, not difficult. Could just say. Chair is also eligible for reimbursement. For mileage to and from the government center if his attendance is required or requested.
Well, it may not be just the government center.
that's also what I thought too, is it might not be. If their presence is requested at GAM when they do like the HHS one, or if it's at the jail or,
Let's just take out government center.
so you want a whole new subsection?
Sentence, just a sentence at the end of that.
There are other,
That's what I had it separated as. As a whole new sentence as chairpersons may receive mileage reimbursement when their presence is requested or required.
Okay.
That's
because law
simple
enforcement
enough.
calls, they've got a fund of some kind they're applied for, and all of a sudden your signature is necessary.
Yep,
You run
emergency
up there
management
quick.
usually requests.
So it's not the government center as much as it is the law enforcement center.
So just add that sentence that Shavana just read.
Yeah, if the clerk could read back what I think we just discussed.
Okay, so that whole section is the compensation of chairpersons and vice chairpersons to be fixed by resolution. The county board chairperson, first vice chairperson, and second vice chairperson shall receive compensation as set by the county board resolution. Chairpersons may not receive additional compensation or reimbursement for attending standing committee meetings of which they are not a member unless their presence is required to establish a quorum, period. Chairpersons may receive mileage reimbursement when their presence is requested or required.
That accomplishes a goal, as long as that accomplishes the goal you're trying to accomplish. I think that's clear about what is and is not compensated. But whether that's what you want to be compensated or not compensated is. So right now, the way that's worded, county board chair will receive compensation for going to standing committees only if they're required for purposes of a quorum. County board chair will receive mileage if they're required for a quorum, or if a county or a committee chair asks them to attend a standing committee and they decide to go. If they're not required for a quorum, they're not going to get paid for the committee, but they will, under that language, get paid for the mileage. Additionally, if the administrator asks the chair to come, or the chair is required to go to Golden Age Manor or any other facility within the county for any reason, they would receive compensation for mileage if they were requested to go or required to go.
Well, that would clear it up. So it wouldn't be any.
So a motion to adopt the language as read by the clerk.
I'll make the motion to adopt it as,
Or to amend the resolution, sorry.
Is there a second?
I'll second it.
All right, motion's been made and seconded to amend the resolution as stated. Any further discussion? Hearing none, all in favor signify by saying aye.
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 Any opposed? Motion passes.
Good luck with clarifying it in your check.
Okay. We can go through, I think the best way to go, since we have Pam, I don't know if the chair, sorry, Supervisor Garvey, I don't know if the chair intends to also consider any comments that she has as we go through.
I'm open to it.
Me too.
I say we go through section by section, just address the section, see if anyone has any language they want to talk about, and then move on to the next section. And then go that way.
And then include anything that Adam had.
Right, and so then I will jump in, notify when Supervisor Jarko has raised a concern within his comments here, and then the group can discuss it that way as well.
Okay.
So Pam, Supervisor Garvey, jump in when you have a section where you'd like something addressed. Jump in when Supervisor Jarko had a concern as well. Okay. Section 221. Any concerns? There were no modifications in that section. Section 222, filling vacancies. There were no changes in that section either. I think there's concern there. Section 223, we just addressed. Section 224. Section 225. I am later going to suggest an insertion of some language to be created as sections 226, 227, and 228, but we'll come back to that later.
That's why it's reserved.
Well, they're reserved, they are reserved. That's why we have reserved sections in our county ordinances so that we can drop new language in without having to renumber everything. It allows us to pull stuff in. Section 2,
Chairman,
sorry.
just to make note, Supervisor O'Connell's online.
Okay. Yeah. Yeah, please note that Supervisor Kim O'Connell is online with us.
Section 254. Change was already suggested by Corporation Council and incorporated into the resolution by the committee earlier. Changes were recommended. Section 255, decorum and ethics generally. Committee will remember or recall, I'm sure, that on page 7 of 19, subsections 3 through 6 were added for contemplation by the board, by the previous executive committee, and were recommended to the new board for adoption. Supervisor Jarko has raised a concern about the language in sections 3, 4, 5, and 6. Supervisor Jarko indicates he has a concern that it may violate the First Amendment.
How?
He does not delineate specific legal arguments for why or how it violates the First Amendment, but I can touch on the topic after I'm going to read his note, why he wants that section deleted, and then I'll be more than happy to engage in a brief conversation about it. He indicates he believes it violates the First Amendment, believes it violates the rights of supervisors to actually carry out the role of supervisor. He indicates that he believes it invites political retaliation, and he believes that the language used in those sections is vague and likely unenforceable. Sorry, I added the word likely, vague and unenforceable. So After hearing Mr. Jarko's comment at the full county board, I did go and start to do a significant amount of research on the First Amendment. As you may or may not know, I am not a constitutional scholar. So it takes me a good amount of time to read all of the back history and cases on the First Amendment to bring myself up to speed. What I can say is the standard for infringing on First Amendment rights is high. It's a strict scrutiny review when the court looks at a government restricting the speech of anyone. And on top of that, strict scrutiny is the highest level of scrutiny when the Supreme Court is looking at constitutional challenges. Okay. There's strict scrutiny, there's a middle level of scrutiny, and then there's a rational basis, which is the lowest level. Strict scrutiny is the highest level. The Supreme Court has ruled not only that you have to apply strict scrutiny to First Amendment challenges, you also have to use an even higher level, or they historically have used an even higher above strict scrutiny level when you're talking about impeding the ability of elected officials to use speech. Because of that, it is possible that Supervisor Jarko's concern is valid. I'm not saying that if the county board adopted this language, that someone would be successful in a lawsuit. I'm saying that there may be better ways to accomplish what we're trying to accomplish, or safer ways to accomplish what we're trying to accomplish without using a language that was previously presented. And so here's my proposal. My recommendation to the committee and ultimately to the board is that we accept Mr. Jarko's request that that language be struck from your rules of order. They were not there before. There are a number of statutory protections for employees. There are a number of federal laws that also restrict the ability of people to say and do certain things to employees of an organization. So the protections exist to an extent. They just would not be memorialized in your own rules of order. However, I do suggest that you add, again, going back to what I said should be reserved earlier, I do suggest find it. That you add a number of sections from the, not model ordinance, template rules of order that were provided to all the board members previously. That template is from the Wisconsin Counties Association. It has been vetted by a TOLUS law, who has been in county government much longer than I have. The sections that they have within their template that I would be looking to recommend adding would be section 2.11, which is subtitled, headed as board relationship with the administrator and department heads. Subsection 2.13, which is official statement by board members, and subsection 2.15, which is titled Board Member Rules of Conduct. The language within those three sections really encompasses the language that was added to the end of our rules. The difference is it has been reviewed by, again, attorneys that are much more experienced than myself in both constitutional law as well as governmental law. Additionally, it is recommended language from the Wisconsin Counties Association. So I know that there are a number of other counties that have adopted this language. And as of yet, I have not seen any challenges to it. And it provides the protections that I believe we were trying to incorporate into the language that we are potentially striking. So it reduces the liability of the county. It's likely more enforceable than language that I tried to put together myself. It provides a level of protection for the roles and responsibilities within the government, within the county that I believe the board was trying to protect. And so I think moving forward with that is likely the better path forward. And we can go through the specific language that's included in the template. If you'd like, I can read through that.
I think, I'm okay with just you generalizing that it covers the things that we have here.
Him too.
And they're not particularly big sections, at least the first 2.11 and 2.13. So that first section, board relationship with the administrator and the department heads. County board serves as a legislative body in county government. That's a reiteration of the type of government that you adopted that the county board adopted in 2010. The county board adopted to be a policy making body and to direct all of your administrative authority to the county administrator. That's something that the county board decided to do in 2010. Again, this just reincorporates that language into your rules of order, which isn't necessary, but it just re-highlights what's already taking place. As such, the county board's role is to enact policy, to implement the policy the county board establishes. The county board shall appoint a person as a county administrator according to section 59.18. The administrator shall perform all duties and have such authority as specified in WSStat 59.18. These board rules and as otherwise may be authorized and directed by the county board from time to time. Department heads are responsible. So then it goes to the department heads. Department heads are responsible and shall report to the county administrator. County board members desiring information or a report from a department head or other county staff shall request such information or report either in the context of a county board or committee meeting. So you have every right to talk, especially to the division head that is part of your committee. So general government would be able to interact and request things of the general government director within the context of a committee meeting. Health and Human Services supervisor would have the right to request things of the community services director, et cetera. Or a county board meeting. So if county board meeting's happening and a topic is in front of the county board members would be able to request things and information from those department heads. Or from the county administrator, meaning your only employee is the county administrator. You have a right to request, all board members have a right to request any information from your employee at any particular given time. So that is the extent of that particular section. Official statements by board members. No board member other than the county board chair is authorized to make any official statement or comment on behalf of the county board. If a board member makes a statement or comment, board member shall ensure that such statement or comment contains language indicating that that statement or comment reflects the personal views of the board member and not the views of the county board. We don't have anything like that in our rules currently. I think that is somewhat incorporated out of the language that we tried to add at the end, that you should be out on social media saying things that may be construed as being on behalf of the county board, et cetera, et cetera. So that's that section. And then the final section is the most substantive. Again, this is where you get into talking about appropriate conduct of county board supervisors. It is less specific, about what actions are and are not acceptable, what types of statements are and are not acceptable, and focuses more on the conduct. So again, my recommendation would be to insert the word Polk, where Polk County is the appropriate county that these would apply to, and adopt those restrictions as they're laid out in the template. Uphold the oath of office, act in the best interest of the Polk County government, refrain from conduct which a reasonable person would deem unethical, offensive, or otherwise contrary to community values, responsive to the needs of the community, represent the interest of constituents by attending and participating in meetings, adequately prepare for meetings and observe the rules of decorum, conduct Polk County business in a manner consistent with law, which again, in and of itself is what a good portion of that language that was attempted to be added just tried to highlight. Should not be harassment of employees. Polk County should be a safe place for people to work. We aren't going to get employees here if we have actions. If people believe that if they come work here, they're going to be the target of a supervisor and political action when staff is just here to do their job, we're not going to get people here. So again, those rules are there. Yes, it limits the conduct, but realistically, there are federal laws that limit your conduct as well. And it's just telling you, you need to follow those federal laws. So again, my suggestion is to adopt those. It goes on for, talks about conduct at meetings. You shouldn't be yelling. You shouldn't be berating people within a meeting. Conduct outside of meetings. You shouldn't be yelling at staff. You shouldn't be yelling at the administrator. You shouldn't be yelling at each other in the halls, etc. Stuff like that. As much as you might want to.
I would say if the, if the town, excuse me, the association has recommended using this language, I don't know why we would not use it.
I don't want to be out of order. So my only question is when we don't have it, and I understand the argument that if it's too detailed, sometimes the devil's in the details, right? You can get in trouble with that. But then how do you bring forward inappropriate behavior? What is the proper channel or what is the proper process to say, this is wrong and this needs to stop and there needs to be action?
Yep, and so that's why we suggested adding the enforcement provision at the end. That does delineate how complaints can be brought forward. And again, that language we pulled directly from. And we can get to that later when we get that far. It's at the very end.
Yep. And I remember reading through this.
And so it talks about the presiding officer has the ability to bring supervisor's conduct into conformity.
During a meeting.
Presiding officer has the ability to report the violation. Law enforcement, if it rises to the level of something like disorderly conduct. I know we had a conversation about that. I think someone raised the issue of, well, what stops the chair from just reporting any, I violated a rule of order in that I spoke out of turn, one time. Okay, if a chair of a committee reports you to law enforcement for speaking out of turn one time, chances are law enforcement's going to say, okay, well, that's not anything that we're going to do anything about, but thank you for your time and move on with your day. Government, often we set rules and those rules require competent and reasonable action on the part of people who are acting in a position of authority. And so competent and reasonable people, hopefully, somewhere along that chain will eventually act competently and reasonably. Hopefully. And if not, realistically, we have bigger problems than we didn't get the language quite right in our set of rules of order.
Because as I'm reading this, I'm looking at rules are violating during a meeting.
So that talks about,
That's the first statement. If the board rules are violated during a meeting, we can do all these things.
take a proper action.
Can we strike that during a meeting?
Let's violated the rules.
So we just read if the board rules are violated.
Oh, sanctions, if the board refers a matter to additional enforcement. In addition to the enforcement procedures established in this section and without limiting any of those provisions, the board chair may refer any violation of the rules to the ethics committee, and such referral shall be considered a verified complaint.
So that's your that's your catch-all. If rules are violated outside of a meeting.
Then the board chair is a person, at least as the language currently stands, empowered to take that action. So it falls on the board chair to keep the other supervisors in check.
And you just gotta talk.
Well, I've been trying to get
I know,
everybody's
I'm sorry.
attention here. and
It's better just to speak
You know,
up
I'm
about
getting
it.
Backed over and everything. Okay, so a question I have is the section in red that we were just discussing, to go back to that a little bit. Joe, if I understand correctly, that's the language that at our prior meeting, we asked you to come up with something. You said you could come up with something, and that's what you came up with. Okay, so this is not the county template, or excuse me, the county association's template.
The language that I drafted is based off of this language, but was more robust.
Okay. Okay, I just want to say that I'm fine, and I agree 100% with Keith about incorporating what the county's association has said and what they have vetted as well. That's all.
Would our council agree that if we leave this as is, we are protected personally by the county, and your opinion?
If we, the language that I previously drafted, or are you saying if we adopt what the Wisconsin Counties Association?
I want to know what you recommend.
My recommendation is to adopt what the Wisconsin Counties Association has put forward. My recommendation is that their much more vetted language is the safest way to find the middle ground between protecting the employees and restricting conduct and not infringing on First Amendment rights.
How would we clarify that in this document so that we could, this page, so that we could send to the county board with your approval? So you're saying adopt this as is,
Eliminate that.
not at all, totally
Straight
eliminate
that.
this and use the, your
Wisconsin
opinion.
counties.
Correct. So my recommendation on this topic would be to move to strike section 2-55 subsection 3, 4, 5, and 6. And to add section 2-26 to reflect the Wisconsin Counties Association template 2.11. Add section 2-27 to reflect Wisconsin County Association template 2.13 and add section 2-28 to reflect Wisconsin Counties Association template 2.15.
All right. Now is that,
With the appropriate words inserted, Polk, in certain circumstances so that it refers to Polk County and so that it chooses county administrator, our proper form of government, which are often bracketed sections. So then you choose the correct one, county administrator.
you think that satisfied your Supervisor Jarko's concern?
Maybe not as concerns, but probably a challenge.
Well, and
Well, it's a concern.
it's a little bit more difficult to argue against the county association template than
Right.
it is to argue with Mr. Losel.
Not to mention it just plain looks bad
Well,
for us as a county board if we don't have, if we object in some manner to having language, regarding the things we're talking about
employees.
and with employees and how we treat each other and other people. What would the public say? You don't want to be ethical. You don't want to be respectful. You don't want to, be held to any standard of conduct. But I think that the counties association language sufficiently addresses that, in my opinion. And I'm no
I
scholar.
would assume we're gonna work our way through this and then at the end, make a motion to adopt all the recommended changes, correct?
You certainly can.
I mean, I don't think we should go line by, each section and have a motion for each section. There's gonna be too many and too confusing.
That is the most substantive potential changes. I would, at least for this particular section, suggest move to,
You want a motion on just this particular section?
We did one on the mileage.
Yep.
So probably any changes we make today, we probably should motion them,
Well,
motion the change.
but the question is, do we motion each change or do we motion a general agreement of the changes that we brought forward?
I think in this particular circumstance, my suggestion would be to move, again, to strike the language in section
255.
Is,
255, 3, 4, 5, 6, and add.
so is there a motion then to strike, subsection 3, 4, 5, and 6 and to add the language that was given to us regarding the Wisconsin Counties Association template?
So I make a motion to strike section 255, numbers 3, 4, 5, and 6, and to insert in section 226, the corresponding section recommended by the Counties Association of 2.11. To amend to add section 2.27 to insert corresponding Wisconsin Counties Association recommendation 2.13. And to insert and amend section 2.28 to correspond with Wisconsin Counties Association section 2.15 in regards to statement, rules of conduct, and interaction with board members and department heads.
Do you feel that's sufficient?
As long as everyone understands what the motion intends, and as long as the clerk has it written down in a way that she believes is sufficient, and everyone understands what they're voting on, then that's good.
Yeah. And we've discussed it enough that we went through each of those. We should know that. So there's a motion. Is there a second?
I'll second it.
It's been properly moved and seconded. Any further discussion? Hearing none, all in favor of the motion signify by saying aye.
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 Any opposed? Motion passes.
Next. Oh, sorry, we were gonna go. Not issue by issue, but section by
Go right
section.
ahead.
Jim's vote too.
Oh, sorry.
Oh, geez, that's right.
Mr. Supervisor O'Connell, are you with us?
Unmute.
He is here, but he is currently muted. He would-
All right, that's fine.
Okay.
It's just if he voted, we should probably know his vote.
Well, the vote passed by voice majority.
Yeah.
We just unmuted.
Should ask him again.
Yes, I'm agree with it.
There, you're with us. Thank you, Tim.
There. Yep.
And your vote on the motion?
I would vote yes.
Okay, it's unanimous.
All right, section 256 regarding meetings, it's the setting of meetings, et cetera. There were some changes related to remote meetings. No suggestion from Supervisor Jarko on any changes to remote attendance requirements or the closed session requirements. So if no one else has anything on those. Okay. Section 257. Supervisor Jarko does have a note in this section, everywhere that it says county attorney, and that's kind of peppered throughout the entire rules of order. His suggestion is to change that to corporation councils or corporation council. That's basically a clerical error or a clerical correction. Back when the rules of order were originally adopted, I'm sure it was the county attorney, and now we have corporation council. So it would be a fine change. I don't know that it necessarily needs to change, but it would be a fine change. Probably a control F type function within the document.
Why don't we just consider that part of the clerical changes?
Okay.
Wants to eliminate himself from any possibility to be associated.
Supervisor Jarko also notes in section 257 ordinances and resolutions. As you all may know, we have 5 different ways to get a resolution in front of a committee. Supervisor Jarko has a note here indicating that our particular set of 5 ways to get a resolution in front of a committee seems too restrictive. A supervisor should be able to ask a committee chair to place a resolution on the agenda of the committee. He says this is, Polk County's rules are more restrictive than it is to get a bill introduced in the legislature. All supervisors should have the right to introduce legislation. I believe this comment to be maybe just a misunderstanding of what the requirements are. All supervisors do have the ability to get a resolution in front of a committee. It just requires you to bring it up to the committee chair. It requires, or alternatively, bring it up to the administrator, or alternatively, bring it up at the end of a committee meeting and say, hey, I want a resolution on the next, or I want at least a topic on the next agenda, but potentially a resolution on the next agenda. If the committee chair says no at the end of the meeting, which at the end of every meeting, we have items to be agended. If the committee chair says no, a voice vote could be called requesting an overruling of the decision of the chair to not add it to the agenda. And then the full committee then has an opportunity to vote on whether that topic or that resolution gets put on the agenda. And then supervisor could also ask that a topic be put on the committee of the whole. And it could also be brought up at the full board of whether or not, again, at the end of the meeting, topics to be considered. You could ask that it be put on the agenda for the next meeting. So I believe there are enough methods. I don't know if an idea is so disliked that one can't get any of those processes to get that resolution in front of a committee. I don't know how that resolution is going to pass, but I don't know that we need more functions. I have not run into the issue where it's been an issue. That doesn't mean that he's not wrong. Theoretically, a supervisor can't just put anything on any agenda at any time. He's right, that is a restriction, but nothing requires us to have that be in place. So that's his comment. Do with it what you will. You could add language that says any supervisor can get a resolution in front of any committee and then come up with a method to do that. But again, I have not run into a situation where a supervisor has had a hard time getting something in front of a committee.
As I've never heard of a problem
Right.
pertaining to that issue in 22 years.
I think in theory, it can be a problem,
Well,
but in practice, it has not. I have not seen it be a
Yeah.
problem.
the first,
It could be the initial resolution you want. The chair may say, well, that's not going anywhere. I mean, if you know, to try to give them advice so the resolution would have a chance to succeed. And then I can see a resolution coming to a chair and them saying, you know, you need to research this further or look at it from this angle but to add more language, I don't think so. I don't know regardless how bad the resolution is or is going to be, it's not gonna pass unless it gets support.
And if we know it's not gonna pass and, you know, there's, say, one supervisor at some future point that wants to do this continually or something, it's a waste of everybody's time.
I would think 5 methods
I-
is sufficient.
Method's
And
sufficient.
can we change our rules of order at any time with the 2/3 vote?
Yes.
So if it does become such an issue that we can't even get a resolution to committee, let's get together and change our rules of order and we'll add another step or another way.
that's right. I mean, anything.
So no action on that. Let's just move on.
All right. Also within that
Excuse
section,
me, but I want to just for our information, anytime we've used the word possible, it's not a legal term. Because anything's possible. I could be hit by a falling dirigible as I walk out the front door. It's not probable, but it's possible, I guess.
Won't be able to address every scenario that's possible either.
That's right. Otherwise, we could be here for every day.
Yep.
Go ahead.
subsection C, generally, the Board of Supervisors shall only consider resolutions, so this is the language in our rule.
Okay.
Sorry, this isn't a comment. Generally, the Board of Supervisors shall only consider resolutions that have been referred up from a committee. Exceptions can be made for matters that are time sensitive or require more immediate action for other reasons as determined by the chairperson in conjunction with the administrator. The language that was previously in here says resolutions that have not been approved through committee require a 2/3 vote for approval. Jarko's comment, and actually I have a comment as well, but Jarko's comment is Supervisor Jarko's comment or request is that provision be deleted and that a section allowing the board chair to pull a resolution to county board if a committee chair refuses to hear it. Again, I think it's a misunderstanding potentially of what the other 5 ways to get a resolution in front of a committee is. I think that the county board chair at any time has the ability to direct me to draft a resolution and put it on the appropriate committee, at which point a committee chair would not have the authority to say, no, it's not going on the agenda, nor would the administrator. It would be the county board chair directing me to put it on a committee. So the function, I believe it's just a misunderstanding of how things can get on a committee is his request. I could be misunderstanding his note, but I don't think a change needs to be made there. But I do think, ever, that last sentence, resolutions that have not been approved through committee require a 2/3 vote for approval. You can add that requirement if you would like. It is somewhat already a function of Robert's rules. In order to suspend the rules, you need a 2/3 vote. And so if, for example, the chair were to put a resolution on the full board and it wasn't time sensitive, or a point of order got made that says this isn't an emergency, there's no reason for us to do this right now, let's send it back to committee if this is out of order, 2/3 of the board could say, okay, well, sure, maybe it's not time sensitive, and so maybe the chair didn't have the authority to put this resolution on. But if we vote by 2/3 to suspend the rules, we can now vote on this resolution. So I don't think the language needs to be in there. There's already a mechanism by which that happens, unless you want to add the restriction that the county board chair, even in circumstances where there's an emergency, isn't able to get resolutions on the full board to be passed without a 2/3 vote. Nothing says you can't do it. It's wasn't there before, and the mechanism exists within Robert's rules to get it accomplished anyway.
So do you suggest we add that?
I suggest that last sentence be removed.
If it's kind of repetitive or already addressed.
Right. The only thing that language does is add a requirement that even if the county board chair and the administrator have put a resolution on the full board in an emergency or time sensitive issue, it needs a 2/3 vote. That's all that language really does, different from the mechanisms that already exist.
And only because it hasn't been to committee?
Because it hasn't been to committee, right?
That's not gonna be very.
Does that come up much at all?
Rarely, but we have had time sensitive things get put on in front of the county board instead of the committee process.
Do you want us to have a motion to strike that line, or is this part of a bigger?
If this committee wants to strike it, I would again suggest
Well, we had a big change.
so this is language that was not in our original rules of order, was recommended as an addition by the previous executive committees.
Is there other changes to this current section?
There are other suggestions, so I can read those, not within that subsection. But
Okay, so why don't we take them as a general change of the section then?
So under subsection D, that language is all resolutions need to be reviewed and approved as to form by county attorney's office, corporation counsel's office. Prior to placement on an agenda, a legal impact note may be added by the county attorney's office if deemed appropriate. No unlawful resolutions shall be approved. The county administrator or their designee shall also review all resolutions and may provide input to the practicability and desirability of the proposed legislation. Prior to placement on an agenda, any resolution having a fiscal impact shall be reviewed by the General Government Division Director to provide input as to the fiscal impact of the proposed legislation prior to placement on agenda. The note from Supervisor Jarko indicates so he requests, I think, that the requirement that prior to placement on an agenda be stricken. His note indicates requiring that county attorney's office, corporation counsel's office review could result in delay. Corp counsel must review prior to meeting. That's the job, but we should not allow corporation counsel to delay, sorry, it's cut off a little bit here, to delay having it on the agenda. Again, it is somewhat I believe, a potential misunderstanding of, or not knowing what the process, at least historically, has been in Polk County. Again, theoretically and possibly, a corporation council could delay resolutions by taking that sort of action. A corporation council answers to the administrator and the county board. And if supervisors are asking me to do a job and I don't do it, I'm gonna get fired. So is it possible that I am directed to draft a resolution and I don't get it done and it therefore doesn't get on an agenda? Sure, it's possible. But in a circumstance where a supervisor gives me a resolution, has all the language in it, and it's my job simply to review it and put a comment on it, if that were to get delayed, that would be probably a political action. And again, the board would have a bigger issue with their corporation council acting politically rather than as your council. So it is possible that adding that restriction would be necessary, but I think practically it's not really anything that needs to be addressed in the rules of order. As you all know, I generally am told this is agended for this date. Usually I have a significant, maybe a month of notice in advance, sometimes a week. I'm noticed this is going to be on an agenda and it needs a resolution. I get a resolution ready because it's already on the agenda. It's not going to get agended until I have a resolution. I'm usually told it's on the agenda, you better have a resolution ready. So again, I think it's a practical, not necessary to change the language, in my opinion.
You're saying that the prior to placement on the agenda doesn't need to be there?
We added this also because this was, I believe, partially my request, because I'm the one who gets those resolutions ready. I get those signatures, and it's always historically been the practice that all those signatures and all the reviewing by the administrator, corp counsel, and general government are done ahead of time. And so I wanted that codified in here to say, these need to be done before that resolution is put on there. So that's also my office reaching out to the administrator, the general government division director, and corp counsel saying, this resolution is on the agenda. Here's the resolution. I need your signatures for it. Otherwise it won't be placed. But I usually, if there's a delay, then I reach out to the secondaries. If they're not available, I reach out to the deputy administrator. I reach out to assistant corp counsel, and I reach out to the finance manager. Like, there's a secondary, thing in place that if they're not available, we do go to the designee if necessary. So this hasn't really been an issue in the past, but that's the reason we wanted it as prior to being put on the agenda, because the supervisors want to have that information when they're reviewing it at committee. If there's a legal impact, if there's a fiscal impact, if the administrator has something that says a note as to why this would or would not be a good idea for the county. So it's just codifying the practice that's already been in place. And it's kind of making sure that we, are able to get those things ahead of time, and we have a backing that says those are needed ahead of time. That's why it seems to be just maybe a misunderstanding of what that's doing.
Right, this hasn't been an issue getting them on the agenda. We just we have our dates from the clerk on when the agendas are going out, when they're reviewed by corporation counsel, myself, and general government. So this hasn't been an issue on getting them on the agenda.
I just want to interject that I agree with Shabana, and I'm fine leaving it in there. Too, there's possibility. I mean, nobody likes to be blindsided, right? And this also prevents, I think, maybe that from happening.
So we're just discussing the addition there, and to this point, we're agreeing that we leave it.
I don't have a strong recommendation one way or the other. Even if you remove it, it's still, the process is going to operate exactly the same. So
I would say if we, since it's here, we just leave it.
If the political aspect, if a corporation council wanted to act in a political manner and wanted to slow a process down, there would be many more options available to me that I could avail myself, or a corporation council could avail themselves
Probably be a
of.
one-time event.
Right.
Good one.
You could quit, yeah.
That's kind of my point, is corporation council's job is to act as apolitically as possible. So the likelihood of that being a concern is low. And so this language was added as part of this round of modifications. It's not in the prior board's rules of order, just prior to placement on an agenda. But it, as Shavana pointed out, it is a operational modification, not a restriction on the ability to get resolutions forward.
Again, if Shabana suggested it and everybody agreed to it once, I don't see a reason to remove it.
So that is everything in section 257. So I think based upon my understanding of the conversation, the only last sentence in C. Right, the only modification would be striking the last sentence in C if the committee would like to do that prior to sending it.
I have one other comment, if I may, that I had before and forgot about it, is that I do not like the language of F, that new language. If we want to, if there's the idea of listing a roll call vote, that however, but I don't like the fact that it must include a vote tally of board supervisors only. Committees that are comprised with citizens members are designed usually by, like HHS is designed by legislation. They are full members of the committee. The idea that we would call them out separately or call supervisors out separately, I think puts a turn on them that is not appropriate, or puts a view on them that is inappropriate.
I think
Same way.
belittling.
That, exactly. I mean,
And-
you're setting them up as not a valid member. They have the same voting right, that they're on that committee by
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 statute.
statute, by legislative statute. The idea that we would call them out individually, I think is very inappropriate, and I would like to see that language struck.
I agree.
Why was it added?
That was a request of Supervisor Olson at a previous, I think he came to a previous executive committee and made the request, and the committee added it at that time, is my recollection. Because it is likely to be contemplated by at least one supervisor strongly. It might not be a bad idea to leave it and try to strike it at the full board, as opposed to trying to
Do it here.
I mean, you can do it either way. You could strike it now and then have Supervisor Olson move to re-add it, or you could leave it as recommended by the previous executive committee and then let it go to the full board and get removed. Either way is fine.
I just, if I understand this correctly, so this was added at the suggestion of Supervisor Olson when he attended a prior meeting, a prior executive committee meeting.
Correct.
So he's not a member of the executive committee, so how does he get this in here?
It was raised as a topic, comment similar to the comments of Supervisor Garvey or Supervisor Jarko. And
Just checking.
contemplated by the committee.
I didn't know that process, so
Yep.
just wanted to clarify that.
I think he came, right?
Yeah, yeah.
You know,
So what are your wishes? I mean,
leave it, and if someone wants to instruct, they can amend it at county board.
I'm good with that. So then, since we've worked our way through this section, we need a motion then to strike part of C, right?
Correct. The last sentence of C, if the
Someone willing to make that motion?
I make a motion that we strike under section 2-57, letter C, the last sentence that reads resolutions that have not been approved through committee require 2/3 vote for approval, that be striked.
So it should be struck.
Yes.
Is there a second?
I'll second it.
All right, motion's been made and seconded to strike that line in last line in sections, subsection C. Any further discussion?
I actually thought it was the other way we were gonna go with it. That anything that didn't go through committee had to have a 2/3 vote. Now we're gonna strike it. We don't want it, so anything can come to,
No,
So
so
that was, I'm sorry. So that was, if I understand correctly, Joe, so that was the deal. I'm not trying to take your job.
supervisors always have the right to talk over corporation council, always.
So I understand this was redundant because we have provisions already in place that
because
would provide this.
if it comes without going through committee, the rules of order have to be suspended
Yeah.
by a 2/3 vote. So if they're gonna suspend the rules by 2/3, they're doing it to allow it to come. All right, I missed part of it then. I get it now.
So for example, if there's a way for the chair in concurrence with the county administrator to get it on in emergency situations, but let's say, for example, the county administrator thinks something is an emergency and wants it in front of the full board and so puts it on the agenda, which he has the authority to do. But the chair is not necessarily on board and doesn't agree that it's an emergency or doesn't think it needs to, or you're not able to get in contact with the county board chair to verify that. Then in that situation, it can be on the agenda, but it hasn't been verified as an emergency situation by the chair. Therefore, in order for it to even be contemplated, it might be on the agenda, so you're fine open meetings wise, but in order for it to be contemplated by the board, they have to vote 2/3 to suspend the rules
Yeah,
to even contemplate the resolution. So you would need essentially a 2/3 vote to contemplate it, not to pass it. It would not necessarily need a 2/3 vote to pass, but you're gonna need 2/3 of the people to say, yeah, let's talk about this. And if someone wanted to stop it, or a group of 5 wanted to stop it, they would have the ability by saying, no, we're not even gonna talk about it.
you know, which has been done with the consent agenda.
Right.
All right, so I'm good. Let the motion go.
Is there-
I missed part of it.
Did we get a second?
Yep, I've got Brandon.
Okay. All right, so any further hearing none. All in favor? We're all familiar with the motion. All in favor signify by saying aye.
Aye.
Mr. O'Connell,
Aye.
all right. Any opposed? Motion passes.
Section 2-58, there were no changes and no comments. Section 2-59. Subsection H on page 11 of 19. Language is the chairperson in consultation with the corporation council shall decide questions of order. A majority of the board may appeal for a review of Robert's Rules of Order in contingency with the adopted rules herein. Contingency, concurrence. I don't know if contingency is the right word, but regardless, the suggestion from Supervisor Jarko is to strike for a review of Robert's Rules of Order in contingency with the adopted rules herein, and to change the word appeal to overrule the decision of the chair. I don't have an opinion really strongly one way or another. From my perspective, it's kind of how you want appeals to operate. The way that we have it structured is a rule of order gets made, chairperson asks corporation counsel if the chairperson would like to ask corporation counsel, but has no obligation to ask corporation counsel on what their opinion is for how to rule. The chair makes a ruling on the point of order. If other supervisors are not satisfied with that ruling or think that it's incorrect, the way we have it structured is you would move to appeal the decision of the county board chair or the committee chair, at which point a review of Robert's Rules of Order would be adopted. So the chair is supposed to consult with corporation counsel, but isn't required to. They make a ruling, an appeal then is made for a review of Robert's rules to make, and our rules of order to make sure that that ruling was correct. Then you would have to go later into our rules of order at subsection something. Section 2-84, which says in questions relating to parliamentary procedure, the latest edition of Robert's Rules of Order as interpreted by corporation counsel shall be the final authority. So point of order gets made, chair makes a ruling, a motion to appeal is made to the Robert's Rules. A review of Robert's Rules occurs by corporation counsel. Corporation counsel makes an opinion and tells the full board, this is what the rule is. Okay, that's how our process currently is. If the full board doesn't like that ruling, then, or the committee, then the committee can say, all right, well, if that's the rule, I move that we suspend the rules. And you have the ability then by a 2/3 majority to suspend that decision and say, we're not going to apply that rule. We're going to apply a different set of rules for this particular circumstance. And then you could move forward that way. That's how our current structure is. We've never advanced that far. But
How could it ever go that far if we say corporation counsel has the final decision?
Corporation counsel has the final decision of what Robert's Rules says. But you can suspend the rules.
Yeah.
That might be the rule, but you can suspend the rules.
I have a
I hate
rule.
parliamentary procedure.
I
hate
mean, I get it. You're giving an opinion on what the rule is, and then whether we follow that or not is up to the board.
Suspend.
The other thing is, we don't follow a lot of the rules. Just so we're all aware. You're allowed to do that by consensus. I mean,
Yeah.
if no one's making a point of order, we're allowed to operate in a manner that facilitates the meeting, so long as the meeting moves forward and things are approved and considered appropriately. And that's fine. The only time I jump in is when it is violating the rules in such a way that it is going to impact the legislative operation that you're trying to accomplish. So if you're trying to pass a resolution and you're not following the rules in a particular way, I'll jump in and say, you have to do X, Y, and Z. You can't be doing it that way. You have to do it this way. But rarely, well, I've never been asked to jump in and say, this is what Robert's rules say. I've only been corporation counsel for 2 years. I don't recall Malia ever having to do it in the 5 years that I was here prior to that. So it doesn't come up very often. Rarely are points of order made, one, and rarely are points of order appealed after they're made. So our process exists. It's a fine process. Nothing says that we have to follow that process. Supervisor Jarko is recommending that instead, chair makes a ruling, the full board can overrule the decision of the chair. And then subsequently in section 2-84, not to jump ahead, his suggestion is in questions relating to parliamentary procedure, the latest edition of Robert's Rules, as interpreted by corporation counsel, is the final authority, subject to the board by majority vote overruling the decision of corp counsel, which the problem that I see with that mechanism is essentially you're allowing a majority of the board at any point in time to say, those might be the rules, but we're not going to follow the rules. So at any point in time, if 8 supervisors just don't want to follow the rules of procedure, they would not have to follow the rules of procedure because a point of order could get made, the chair could rule on it, an appeal could be made to me, at which point I say the chair is correct, that is the rule, at which point 8 people say we're not going to follow it. Okay, so then the majority just gets to change the rules. We have a process by which changing the rules requires 2/3 of a vote, or 2/3 of the board. But now we don't have to follow the rules simply because a simple majority at any point in time says we're not going to follow the rules. So it doesn't make sense. The way that those things function together just wouldn't work, I think, the way that's being suggested.
So,
So my recommendation,
so we're good with what's been added previously, and then it's Mr. Jarko's comments that that you feel are, you know, in opposition to this.
correct. And so I don't like the word contingency. I don't think that's the right word. Concurrent
We want to keep it at
contemplation.
requiring a 2/3 if it is going to get challenged or suspend the rules.
I would strongly suggest that the process that currently exists as we.
Majority can't do it. Only 2/3 can do it.
Right.
Because any critical decisions that we take on are 2/3.
Well, and if we're suspending the rules, we're setting us up for a future problem if somebody challenges it. Possibly.
You could, so again, Supervisor Jarko's recommendation, subject to the board by a 2/3 majority, or by a 2/3 vote, overruling the decision of Corporation Council, that would be fine. That just kind of puts in words what Robert's rules would already allow.
But we've already established that your decision is an opinion on whether we're following the rules. Why would we overrule that?
Because someone didn't like his decision.
Well, but it's not really,
In a majority of the board, if we allowed a majority to overrule it, it would be overruled versus requiring 2/3 to overrule it.
okay, but my point is, if we're gonna overrule him, why would we overrule him at all? Because he's giving us an opinion on the rules.
Because
Then
somebody
we-
don't like his decision
Well, I know, but then we suspend the rules.
with the 2/3.
With the
Right,
2/3.
right.
So
This is kind of repetitive.
It's adding a process that
Well,
we
we
don't
don't-
need in any way.
absolutely what we don't want is that a majority can
Right.
do that.
Yeah.
Well, but you would sidestep that suspending the rules, but basically declaring that we don't care what the rules are, he's wrong. I mean, I don't see a reason to have that.
Well, I don't think anyone sitting here does, but
Let's leave it as it is.
Yeah.
Yes.
I would suggest changing that word contingency to conjunction.
That could just be a clerical.
Yeah, I think it's.
Yeah.
Include that in the clerical changes.
Section 2-60. Voting.
There's still and maybe I didn't get the full, what the decision was last time on that whole, what the opposition should say. It did say same sign. There was a recommendation to change it to nay or no. And again, when Adam was, or Supervisor Joko was, online last time, or Supervisor O'Connell right now, like how that comes into play if it's the same sign and they're delayed on their response time. This is why we recommend changing it to either nay or no, because then we know what the vote should be.
we'll know what the vote's gonna be next.
Uh-oh.
Don't worry about that.
But just as a, reminder as to
To
why
write that on my hand so I don't forget. I'm used to saying same sign, so
We're gonna vote with the clicker.
that's not a bad idea.
So then we won't need any yay or nays.
So
At which point we might have to change our rules of order.
Yeah.
When we have that
I
fully
guess there'll
implemented.
be a lot more roll call votes.
will we have to change it? Because I mean, it's still a roll call vote.
I don't.
I think the chair is gonna call for the vote, however they call for it. I don't think we could put it in there, but
Do you want to just maybe remove that sentence that say the opposed say something and just leave it?
I think it should say something.
whether it's followed or not, it should say something.
Right. No one's gonna make a point.
Reasonable people would not make a point of order.
We're gonna operate by consensus anyway. I think that if we're gonna put a rule in place, Robert's rules say that saying same sign is not advised for a number of reasons that we've addressed. Video appearances being delayed, the fact that a person could vote late on a yes and it could be construed as a no in person. There's a number of different reasons why they say that it is not optimal to say same sign, and to have a different word that does not sound similar to the previous word.
A and nay sound similar as well.
Correct. So no,
Yes and no.
So for this meeting, at least you'll be able to get away with however you want to do it. But after county board, you won't be able to.
I see that. I have no problem with this. I mean, I think it makes sense. I've never really thought about, the delay portion of it and stuff, so.
Yeah.
okay, so leave it the way that it's written with the I and the nay.
Yep.
Okay, do we want to keep nay or would no be preferable?
Is somebody going to say
Robert's rules want.
a different sign?
I don't know. I think they say no. I'm not
No?
sure.
Because it sounds less similar to I.
Aye.
Do we want to change that?
Can we say it the Scottish way and then we can see that there's a difference?
We don't know what that is.
Oh, I'm Scottish.
But what's the difference?
So we say A, and in Scotland, they say eh.
Don't go to Canada for
Yeah.
Let's not confuse this. It could be Canadian and EH.
Sorry, I'm trying to have a
Don't they
little
put a
bit.
swear word in front of it?
I might, yeah.
Let's leave it as, from this point forward, we'll try to, as much as possible, we'll try to clarify,
Yeah, it's possible.
signify by, those in
I think
favor
every
signify by
chair-
saying aye.
Every chair can do whatever they want to, I say.
Okay, but
And
let's,
declare it.
let's leave it in there though, because, technically, we probably should have a difference.
The only time it's gonna become an issue is if there's a contentious vote on the ayes and the nays and someone wants to recall a
Challenge.
voice vote, which in that situation, people are gonna ask for a
Roll call.
roll call.
Roll call. and-
It's unlikely to become an issue. It's a much bigger issue for much larger assemblies, for much larger committees, much larger boards. 15 people at most is unlikely to become too much of an issue with it.
And then isn't it who hollers the loudest when you vote, which
That's-
side wins?
That is,
Oh, jeez.
That's a voice vote.
that is often why voice votes are not preferred.
But anybody can ask for if it's unclear, any of the members can ask for a roll call vote.
Challenge the decision of the chair if they call it one way and they don't believe it was.
Correct. Anyone can call a roll call either before the vote, or if you disagree with the chair's determination of the success, you could call a roll call after the vote has already.
Challenge the decision that the chair made on how we called the vote.
I don't think it's discussable or arguable. I think that if the motion is made to challenge, then a new vote occurs. But yes, I believe technically it is a challenge to the determination. But it's not, I can't think of the word. It just happens then.
We had a supervisor that called it every time. Remember?
Yeah, if you challenge the decision of the chair, isn't that put to a vote?
The reason that it's not put to a vote on voting is because you just end up in a circle, right? Okay,
It's
put
just,
to a vote
You could challenge the decision of the chair and call a roll call vote
On
on the challenge.
challenge. I suppose, sure. Sure. You might be right.
Cause you wouldn't want a voice vote on it, cause then it would
Right.
turn into a shouting match.
May be correct, but historically,
Cause there's been times when the chair has called the voice vote and it was close. And it, you know, it didn't get challenged, but if there was grumbling that, you know, you could hear the grumbling. But no one challenged, but someone, if they disagreed, they should have challenged the decision of the chair immediately.
I've only had one challenge since I've been here, and I maybe incorrectly advised that a roll call was called after the voice vote, therefore a roll call should occur
Without a challenge,
without
The
without a
chair's
specific
already-
challenge.
said motion carries.
Would essentially be a request for, it would essentially be a challenge. I mean, if a voice vote happens and I say, I want a roll call on that vote, it's essentially a challenge.
Point of order. And then
Clarity.
I'll have to look up what the exact process is, but
But it's for clarity, it's, you know, I mean, it's for clarity to show that indeed it did pass.
Next week.
that's all in Robert's rules. That's not anything that we have to worry about.
Let's just, I mean, I agree with the having, you know, another sign, you know, in our rules. We should just leave that there.
We do have, since this is a slightly different executive committee, we have the provision in here regarding failing to vote. They've been no votes. If you are not present or don't vote. So if you're not present without an excuse, or if you are present and just don't vote, that's a no vote. Doesn't have to be. You can set the rule to say whatever you want. That's what we've done. It's been in our rules for a long time. It's what we've done, unfortunately, many times in the somewhat recent past. I'm only bringing it up if there was a suggestion to change it. I'm not suggesting that you change it, but if someone wanted to, they would have the ability to.
Why we would change it. I mean, if it's dependent on someone who's not there, then maybe it shouldn't pass.
I think that's the kind of contemplated why the rule existed in the first place. All right. Subsection or section 2-79 established composition. That's the establishment of the 5 standing committees. Section 2-80 appointment of committee members. No changes were made by the previous executive committee, or no changes were suggested by the previous executive committee. There is a suggestion from Supervisor Jarko after subsection B. Citizen members should not vote on chair of committee. Only elected officials should vote, determining the chair of committees.
no, thank you. Again, I just view this as an effort to belittle statutorily citizen appointed members. So if we don't I mean, gosh, are we breaking a statute if we don't let them vote? Because they're authorized by statute to vote, right? So if we say they can't vote, we're kind of maybe, I don't know, I'm not an attorney, but yeah, it's just another effort to belittle those folks.
Well, I mean, I guess I'm not, if you're a member of the committee, you're a member of the committee and you're a voting member of the committee, regardless of whether if you're an elected or appointed or however you get on that committee, if you're a member of the committee, you should be able to vote.
And they can't be chair. Regardless.
Right.
Which I think was the concern, is that if they're voting members, could they be the chair? And if they could be the chair, but then they sit on executive, and we now have someone sitting on executive that's not even a county board member.
Specifically listed that they can't be chair. That is
Yeah.
in the rules.
You know?
Yeah, that's already covered, so.
Yep.
All right. Section 2-81. I don't think there are any. Section 2-82. Establishing the responsibilities of each of the committees. There are no comments. Section 2-83, modification of division, no comments. Section 2-84, that's the final authority on parliamentary rule issues. Again, the language originally was in questions relating to parliamentary procedure, the latest edition of Robert's Rules of Order shall be the final authority. Previous executive committee suggested the addition of latest edition of Robert's Rules of Order as interpreted by Corporation Counsel. So the insertion of Corporation Counsel as the interpreter of Robert's Rules, so that there's a
Couldn't we
check.
have done that through AI?
Say that again.
Couldn't we have asked Robert's rules to interpret it through AI?
I don't think I understand the question.
Except for AI, it's not always correct.
Yeah,
No,
you mean like,
but I
Ask
mean,
for
the
interpretation.
way it was before, the book can't talk.
Oh,
So who, you know,
Point
it
of
says the
clarification.
latest edition of Robert's Rules of Order shall be the final authority. Like, so who are you gonna ask, the book?
Right,
that would
Or
be-
which one of us is gonna be the expert?
right. So that's why we added as interpreted by Corporation Counsel, so that it's a check on the chair's decision-making by a, hopefully, apolitical, neutral party,
Such as yourself.
such as myself.
Such as Corporation Counsel.
Yes.
There is a so that was the suggestion of the previous executive committee. The note or comment from Supervisor Jarko, as previously highlighted, is that he thinks or suggesting the addition of the language subject to the board by a majority vote, overruling the decision of Corporation Counsel. We discussed that already. I don't know if you want to talk about it again. You could add that sentence. My suggestion would be, if you're going to add that sentence, that in order to have the rules work the way that you are creating the rules, you would want to change that from simple majority to a 2/3 majority. There's nothing wrong with the language itself. It's just whether if you add simple majority, it becomes a problem. You'd also just not add anything because, again, by operation of Robert's rules, theoretically, you can already do that. So it's somewhat extraneous language.
They leave it alone.
Yeah.
Okay. Then we get to section 2-85 regarding enforcement. I already made my recommendations for clerical errors at the end, or clerical changes at the end of that subsection. There is a note from Supervisor Jarko. He has the entire section struck with a note. This is a recipe for political retaliation. It should be deleted. State law has plenty of appropriate remedies. We don't need to add more. That are of questionable enforceability.
Say leave it in there and we'll cross that bridge when we come to it.
If we have.
would agree.
And this is the county association's recommended language.
Correct. It is pulled directly from the Wisconsin
Right.
Counties Association. It is added at the end, so subsection 2.15, which is already contemplated, and this complete additional section 5 in the template are both additional rules to consider. They are not stated by the Wisconsin Counties Association as hey, you should absolutely, these are the things you need to have. They're, hey, these are things that if you want to have them, you can add them. Just so we're misrepresenting what the county's association is. The enforcement provision and board member rules of conduct are not necessary to have within your rules. They are things that boards may want to have if they want to have the ability to enforce certain actions. And we pulled them, I think, word for word from Wisconsin Counties Association section as requested by the previous executive.
Yeah, it'd be kind of silly to make up any rules. If you're not gonna have enforcement. Why would you have any rules?
So we're gonna leave this in the resolution. Somebody wants to argue it at the
Board level.
county board meeting,
Make their
then we can do that.
pitch and see if they can get it pulled. All right, I'll do it.
So with that much discussion on it then, and I guess this is the question for both the county board chair, administrator and corp counsel, do you want rules of order under a committee of the whole then for a more robust discussion? Not necessarily even going line by line, but just for those supervisors to bring those concerns forward for discussion? Or do you want to just leave it as whatever and they have to make that motion with all that language ahead of time? Like, what do you think is the best?
Well, everybody gets a copy of it in their hand prior to county board.
They will get it this afternoon as soon as I make all of these.
Yep.
There should be no reason we need a committee. Conduct business and
Somebody wants to strike a section or argue a section, they'll have that opportunity.
under the current rules of order, they'll have that opportunity.
Hopefully.
Unless they don't get a second.
That's true.
You'll get one.
It's possible.
Gotta.
All right, I make a motion, we send resolution 2026 to the full county board, with a full recommendation.
I'll second that.
Motion's been made and second to send the resolution 2026 to the full board with recommendation
As amended.
As amended.
as amended today. Everybody understand the motion? All those in favor signify by saying aye.
Aye.
Any opposed signify by saying nay. Motion passes. All right, identify subject matters for the next meeting to be determined.
So I have a procedural question, but maybe this isn't the best time to address it. I can talk to Mr. Loso about it.
Go right ahead.
Okay, so I just want to make sure I understand correctly. So theoretically, I wouldn't do this, but theoretically, I could attend Environmental Services Committee meeting. And if the chair of the committee said it was okay for me to participate, which by the way, I kind of like it when other supervisors can attend a meeting and it shortens things up at county board. So theoretically, I could attend, and if the chair said I could participate, I could, without being on the committee, I could make suggestions that would get incorporated into resolutions or ordinances without the committee even giving me permission to do that.
Wait a minute. How would you get it on the agenda or anything like that? It would have to be discussed among the committee members and then,
Yeah, but if it's coming from someone who isn't on the committee, I guess my opinion, for what it's worth, is that the committee members should vote on that. And
vote on allowing the
yes, on allowing,
person to participate.
no, on allowing the person to amend the committee business or be able to amend a resolution or,
That, I don't, would the chairman of any committee allow that to happen?
well, it just happened today.
Well, we didn't, Pam gave some opinions and
No,
stuff, but
I'm referring to the section F
we're,
where Supervisor Olson attended as a non-committee member. He made a suggestion that suggestion was put in here without the committee members acting on it.
Well, I don't specifically remember, but I think the committee members of the executive committee did decide to add it.
I don't think they did,
I could
but
be-
that's just, I could be mistaken as well.
Regarding like Adam's suggestions there, that was presented to Russ.
Nope.
And Russ,
And I don't have
the
a
general,
problem with that
general
either.
government.
Well, we asked for it.
Yeah,
Yeah,
I don't have a
You
problem
had
with that at
anything.
all, because we as a committee then
Ann's
decided,
saying is something got in there that she doesn't think.
I
we
understand. I'm
discussed
just
or
trying
we
to
want
understand
to
the
go
difference of how that got in there versus like how Adam's suggestions got in. So you're saying that Adam's suggestions were generally accepted by the committee to be added, and this was not.
so the committee decided whether or not to add those suggestions as we reviewed them one by one. I think I'm fine with that. But
Generally,
Yes, yes, sir.
Yeah, I think at that meeting, because they weren't adopting the rules of order, they were going through the recommendations, that things were added into that by consensus for this board and this committee to look at with those suggestions. I'd have to go back and look at the tape to see what that meeting looked like.
yeah,
I think that's what happened.
but generally speaking, I believe Supervisor Duncan, generally speaking, I think Supervisor Duncanson is correct in that a supervisor would not generally have the ability to, over the objection of the committee, especially if put to a vote, have something added to a resolution. They would not have that authority. So your concern, I understand your concern, and it could have been a misunderstanding on the part of staff in changing what language was put in there. Could have been a misunderstanding on what the consensus was. I thought, my recollection was that would be added, but I could be mistaken. But generally speaking, I think Supervisor Duncanson is correct that a supervisor would not be able to just attend any meeting and have, just because they and maybe the chair agree that something should be added, that it would be added without a vote of the committee. The committee is the body making the decisions, not the chair.
If that happened, that person should be, or comment should be ruled out of order.
Right.
If they tried to interject and force something into a resolution,
well,
the chair should just rule it out of order.
I guess I was surprised to see it in there. And I was kind of wondering how it got in there, because I could be mistaken. I can take a look at the video, because to my memory, he threw it out there. There was little discussion. There was no consensus, and it wasn't voted on. It was just thrown out there is my memory of it. So like I said, I could certainly be mistaken in that, but I just want clarification so everyone is on the same page and everyone knows what the rules are. I mean, I have no problem whatsoever with any, don't get me wrong, with any board member attending committee meetings. I welcome them, I've had Cam at HHS, invited him to come and sit at the table, invited him to participate. I have no problem with that whatsoever.
Just a general question on that. I mean, obviously I wasn't there. Did the committee then discuss his proposal?
I believe
I,
pretty briefly, I think,
And there was no vote on it or no consensus? It just,
not to my memory.
okay.
I think it was more along the lines of, depending on the vote at that committee level, was a roll call vote is documented on who votes for what. When the other votes are done unanimously, and was there a way to, with the roll call vote, how each member voted of it?
I'm also looking back at the agendas, and it was in the agenda packet with that change at the last one from April. So it would have also been discussed at the April one.
So how did it show up in there to begin with?
I know he was here and spoke to it, but unless there was not an official consensus.
Probably originally, everything was in there. every change that came from anywhere was in the first draft. And then we started to pick it apart from there. But whether we voted on to let it go forward or let it go to the county board to decide whether it should go forward, not kill it in committee.
Well, let's just kind of generally agree to this. I mean, if there's a non-standing, member at the meeting, you know, we can certainly take, comments, advice or whatever, but if that person has something they want to get into a resolution or be acted on, if it's not on the agenda, I don't know how they can do that unless the committee agrees.
Well, it would be on the agenda. If you're trying to modify, on the agenda.
So it's a non-committee member modifying.
Yeah, I understand, but, I suppose the non-committee member could make the comment, but wouldn't a committee member have to then make the motion?
Yeah, or the committee member could make the comments and the committee could take no action. And then like what's the whole county board would be who's acting on it anyway.
Yeah,
But just kind of to pull it in here, I guess,
But we
I
asked,
don't understand.
we asked all the supervisors if they had something to bring it forward. And then it got in the first draft. Anything. The clerk had some, clerk council had some, the administrator may have, Brad Olson had one, it got in there. And the same thing, before this meeting, we asked if anyone has anything, either come to executive or get it to us, or it's not gonna get in there. Because a very slim chance that you're gonna do something at county board and get it in there if it didn't get to committee. So that's definitely how it got in there. And whether or not we were voting on every line item, we discussed every line item, but whether we voted, whether it went to county board or didn't, I don't know that we were, I think we were doing it more as a package than each item.
So my recollection is we reviewed what had been marked.
Yeah, proposed.
Yeah.
So what I can see from the minutes and the agenda, that proposed language was not in the packet that went out for the agenda for the March executive meeting. Per the minutes, Supervisor Olson attended the March meeting. And then at the next one, there was language discussion brought up by, well, Supervisor Olson, who's here, and I think it looks like he was the only other one here that time. And then for the further discussion at the April meeting, that language was in there. It was not struck or further discussed at that time, and now it's still been in there for this.
well, I mean, if it was
So it was,
as contentious as it may
in
be,
April.
maybe it should have been, addressed at the last meeting. And it would, then it wouldn't have been here for this one, but somehow it got skipped over last time, it sounds like.
I just want to make sure everybody's on the same page is all.
Yeah.
And we know what it's okay to do and what it's not okay to do. Because, I mean, personally, I don't want to do anything I'm not supposed to do. And I want somebody to tell me if I am.
Well, so noted. I mean, good discussion, but I don't see any action to take on that. So identify subject matters for the next meeting to be determined.
That's your job. Well, that's your job. but
I showed up at the committee meeting and 2 minutes into my first meeting, I got appointed as. That's all it was.
And you've done a fine job too,
You have
Pete.
done a fine job.
I don't know what to, we'll work with Mo and.
Yeah, normally executive is only called if needed.
If needed.
It's not a standing committee.
Right.
We've met quite a few times, but only because of rules of order. If it wasn't for rules of order, I don't think we would have met.
we'll just leave this to be determined then.
You'll call them or you'll call the meeting and
Somebody will talk to me about what they need to, call a meeting together for, and we'll put it together.
Typically, it's the second Thursday, but historically with this committee, we have kind of moved that as
Okay.
we just
necessary.
can't have it the day of another meeting.
Okay.
As long as there's no ethics violations, we probably shouldn't see each other for a couple years or.
You'll have your annual review in the fall.
That's right, we have an annual review.
So, sounds good to me. All right, we'll move on then. And then what's the final motion here?
A motion to adjourn.
Second.
Second.
We are adjourned at 11:06.
Thank you for letting me sit at the table.